Hello, I'm David Holland KC, and I'm here with my colleague from Landmark Chambers, Tom Weeks KC, to discuss the quadrilogy of recent Supreme Court cases which deal with the law of private nuisance. These cases are, of course, Fearn and Tate, decided in February 2023, Jalla and Shell, decided in May 2023, Davies and Bridgend City Council, decided in May 2024, and United Utilities Water Limited versus Manchester Ship Canal, decided in July 2024. Now, these cases all involve very different facts. Fearn and Tate famously involved visual intrusion into domestic flats from the viewing platform of Tate Gallery in London, a case in which Tom was involved. Jalla and Shell involved pollution of the Nigerian coast from an oil spill offshore. Davies and Bridgend involved the escape of Japanese knotweed spores into a domestic garden, whilst the United Water Utilities case involved pollution by sewage of the Manchester Ship Canal. So, Tom, sites, spills, spores and shit. Given the very different factual scenarios, is there anything we've learnt from these cases?
So I'll respond to that, David, by making 5 points, I think. The first point is, despite the extent to which our lives today are regulated by the state, these cases demonstrate the life and vitality of the law of nuisance. So if you remember in the Court of Appeal in Fearn, the Court of Appeal backed away from saying there was a cause of action in nuisance arising from what they called overlooking, because of the extent, at least in part, to which overlooking was already regulated by the planning system. Equally, in United Utilities, the Court of Appeal said that there was no cause of action in nuisance for the owner of the canal against a sewage company because of the existence of a statutory regulatory scheme, which the Court of Appeal thought impliedly overrid any cause of action in nuisance. But in both cases, the Supreme Court disagreed. They held that in each case the claimant did have a good claim in nuisance. So these cases demonstrate that even in an area where there is a high degree of state regulation, nuisance has an important role to play.
Well, you can certainly say that the cases show the continuing vitality of the law of private nuisance in the 21st century, dealing with the very different factual scenarios in this case, everything from the viewing gallery of the Tate through to the escape of Japanese knotweed spores and oil spillages off the Nigerian coast. Do you think we've learned anything else?
Well, my second point is that when it comes to nuisances caused by activities, we've learnt that the law of nuisance proceeds by a set of rules. Now, if you remember, when it comes to whether a defendant is liable in regard to how they've dealt with a natural hazard, you simply ask the question whether the defendant has acted reasonably. The minority in the Supreme Court in Fearn thought you could utilise the same concept of reasonableness and you'd determine whether a defendant was liable in nuisance for an activity by asking whether the defendant had made an unreasonable use of his land, having regard to the interests of the defendant, the interests of the claimant, and the locality. So what you'd be doing would be engaging in a fairly freewheeling, multifactorial balancing assessment by reference to quite an ill-defined criterion. The majority in the Supreme Court thought the law should aspire to do better than that and reduce the principles of nuisance as they apply to activities to a set of rules. Essentially, the rules are a malicious interference with a neighbour's use of land is automatically a nuisance. If you're making a common and ordinary use of land, that can never be a nuisance. Otherwise, whether it's a nuisance is a threshold test, depending whether you've seriously interfered with the amenity of your neighbour's land. I think this is to be welcome. Our intuitions and beliefs about the boundaries of acceptable neighbourly behaviour can, I think, be reduced to these principles if we think about our own neighbours and how we should behave. And also it makes it easier to work out if there is a nuisance in any particular case. If you're applying a set of rules, it makes it easier for us as lawyers to advise people.
I agree. Lord Legate emphasised that one has to be very careful using the word reasonable in the context of private nuisance. He emphasised that private nuisance does not turn on some overriding and free-ranging assessment by the court of the respective reasonableness of each party in the light of all the facts and circumstances. In some circumstances, such as, for example, case management decisions, that might apply, but not in the law of private nuisance. There were principles, and he set those out in some detail. What else have we learned?
Well, my third point, I think we've been told things maybe we already may have known. For example, in Jalla, we were told by the Supreme Court that a continuing nuisance involved a activity or state of affairs for which the defendant was responsible, which continued over a period of time, causing harm to the claimant. It didn't cover a situation where you've got a one-off event which then causes harm over a period of time. I think we could probably have predicted that. Equally, in Davies, the Supreme Court told us that you can't claim damages for nuisance in respect of a loss that would have been sustained even if the nuisance hadn't happened. Again, something perhaps we could have guessed.
I agree that the Jalla case really confirms the pre-existing law on what is and what is not a continuing nuisance. And whilst the Davies case, although it does involve a claim in private nuisance, really deals with the common law test for causation.
And particularly striking, perhaps, given it doesn't raise any interesting point of law, Davies was a case, involved a claim for £4,900, involving 3 appeals, including to the Supreme Court. Reminds me a bit of my case, Cusack and Harrow, 3 appeals, including a appeal to the Supreme Court about whether a local authority could erect a bollard in the pavement.
Have we learned anything else?
My fourth point is that we have certainly learned something important about the locality principle. So this is the principle as articulated in Sturgis and Bridgend, that what might constitute a nuisance in Belgrave Square might not constitute a nuisance in Bermondsey. Of course, Bermondsey was chosen, this is a 19th century case, Bermondsey was chosen because it was where London's tanneries were situated, and as I think we both know from visiting tanneries, for instance, in Marrakesh, they are quite smelly. Now, I've always understood the locality principle as meaning that the standard, the threshold for whether something is a nuisance varies depending on the locality. So the level of intensity of the immediate interference in Belgrave Square might be less than in Bermondsey. But Lord Legate in Fearn said this would be contrary to basic sort of democratic principle. And instead, the locality principle is simply and solely about what constitutes a common and ordinary use of land, which, as I've said a moment ago, exempts something from being a nuisance. And it seems to me this is one of the most important aspects of the decision in Fearn, but it has been ignored by pretty much everyone.
So, he was emphasising that locality is relevant, but only as a factor in the crucial determination of what is or is not a common and ordinary use of land. Finally, what else have we learned?
Final point, perhaps someone in the Supreme Court has a dry sense of humour. I did notice that, if you remember, United Utilities have been in the Supreme Court twice, so this was the second decision. And it was delivered on the 2nd of July this year, which is 10 years to the day when the Supreme Court delivered its decision on the first occasion that United Utilities went to the Supreme Court.
Now, is there anything we haven't learned?
We've learned nothing about remedies, and I'm keen to know more about what the Supreme Court thinks about remedies. We know from Coventry and Lawrence and other cases that there is a fair degree of fluidity in thinking about remedies at that level. And it's also something I think we as lawyers, it is often difficult to advise clients as to the likely remedy. I'm particularly interested to learn more about the circumstance in which negotiating damages would be awarded. My understanding of what Lord Reed said in one step is that you get negotiating damages in circumstances in which your right is the sort of right which is frequently traded away. But that has the paradoxical effect that if you've got a very important right, which people don't tend to trade away, you might get less money because your damages will be compensatory. Whereas if you've got a less important right that is frequently traded away, you may get more because you get a slice of the profits. So I'd like to learn more about what the Supreme Court thinks about remedies, perhaps an opportunity for finding out what at least someone thinks about remedies will be provided by United Utilities, because presumably the never-ending litigation will now proceed to consider the question of damages.
I agree. Despite the guidance given in Coventry and Lawrence and subsequently in One Step and Garner, I think there is still Supreme Court guidance required on when one gets damages in lieu of an injunction and how one calculates them if and when one does. Tom, thank you very much.